The timing is not an accident. Harry lands in Britain chasing goodwill, chasing visibility, chasing whatever version of rehabilitation he has convinced himself this visit represents. And the British legal system has quietly scheduled a reckoning to meet him at the door. Not after, not before, during, the ruling in his phone hacking case against Associated Newspapers will be delivered while he is standing on British soil, with at least 48 hours private notice given to both legal teams before the public sees a word of it. That is not coincidence. That is choreography. And both sides already know it. That is the detail that changes everything. The 48 hours of private notice handed to Harry's legal team and to Associated Newspapers Counsel is not procedural courtesy. It is a window, a loaded and deliberate one, during which two opposing camps will sit with a verdict that the rest of the world cannot yet see. They will read it. They will prepare. One side will be composing relief, the other something far harder to manage. And Harry, standing on British soil for the first time in months, will know exactly which side he is on before a single headline is written. What we do not know is which side that is. The ruling itself remains sealed. The judgment, whether it vindicates or dismantles the case he has spent years treating as the cornerstone of his public identity, has not leaked. What has leaked is only the mechanism, the timing, the private notice, the collision with his visit, the shape of the thing, not the wound inside it. And to understand why this particular verdict carries such specific structural weight, you have to go back to how this case was ever brought at all. And to understand why this verdict carries such specific structural weight, you have to go back to how this case was ever brought at all. The scaffolding was built piece by piece, over years. Harry's legal team had been moving through the British courts on multiple fronts simultaneously. Phone hacking against the Mirror Group, unlawful information gathering against Associated Newspapers, and this case, the action against the Home Office over his security arrangements. Each strand was separate. Each carried its own risk. But it was this one, the security claim, that first cracked open the relationship between Harry and the British legal establishment in a way that could not be quietly repaired. The moment that changed the terms came in 2023, when details from Harry's witness statement, material describing the precise nature of his security concerns, the operational gaps he believed placed him at risk, surfaced publicly before the Home Office had been given any formal advance notice. It was not a small procedural slip. The Home Office, caught reading its own sensitive position in the morning papers, was furious. Suella Braverman, then Home Secretary, made no effort to conceal that fury. Her office's response was immediate and institutional. This kind of procedural ambush would not happen again, not on any active case touching government security interests. What followed was a tightening of the pre-notification framework that now governs how sensitive verdicts are managed. Both legal camps, the Home Office's lawyers and Harry's own team, were brought into a structure that requires advance, confidential disclosure of judgment timing. The idea is containment, not of the verdict itself, but of the chaos that surrounds it when a ruling lands without warning in a live, politically charged case involving a senior royal figure and a government department. The leak had forced the system to build a better seal, and that seal is now precisely the mechanism synchronizing the ruling with the moment Harry steps onto British soil. There is a particular irony in that. The protocol designed to protect the Home Office from being blindsided is the same protocol now delivering Harry into a controlled private confrontation with whatever this judgment contains. He built the mechanism that now governs his own moment of reckoning, and his position going into that reckoning was not clean. It had been eroded, specifically and materially, by what emerged during the later stages of the case. The G-string incident, a tabloid story Harry had long cited as emblematic of the invasive, degrading coverage that justified his legal action, was examined and found to have a more complicated origin than his account had suggested. The Mr. Mischief coverage, similarly held up as a clear example of fabricated or maliciously sourced material, was subjected to scrutiny that introduced sufficient ambiguity about how the information had reached the press. Neither disclosure destroyed his case outright, but they arrived late. They arrived during a phase when the judgment was already taking shape, and they gave the presiding judge something Harry could not afford to leave in the room: doubt about the cleanliness of his narrative. A case built on the argument that he was a victim, systematically, deliberately targeted, needed that argument to survive contact with the evidence. In two specific instances, it did not survive cleanly, which brings everything back to a single afternoon in 2019, and a decision that at the time must have felt like the beginning of something. It was in fact the beginning of this. In 2019, Harry had options. That is the the part that cannot be overstated. He had the means to leave, the platform to speak, and a transatlantic move already forming on the horizon. He could have chosen silence or distance or the kind of controlled narrative management that the palace had practiced for generations. Instead, he chose a courtroom. Specifically, he chose a British courtroom, governed by British disclosure rules, presided over by a British judge, in a country whose press he had spent years accusing of targeting him with a ruthlessness that bordered on the pathological. The decision to pursue Associated newspapers through the English legal system was framed at the time as courage, as defiance, as a man finally refusing to absorb punishment quietly. And on a surface reading, that framing held. The case concerned a letter Meghan had written to her father, private, personal, emotionally raw, which the Mail on Sunday had published in 2019. The claim was clear. This was a privacy violation, a breach of copyright, an act of press intrusion so egregious it demanded formal accountability. And crucially, it was winnable. Meghan won that case. But Harry's relationship with the British press was a longer and more complicated wound, and he decided to reopen it in the same arena. The original claim against the Mirror Group, the litigation that would eventually consume years, generate extraordinary discovery demands, and force the excavation of decades of journalistic practice, began from the same instinct that the British press had not merely been intrusive, but had operated a deliberate, institutional campaign of unlawful information gathering against him specifically, that this was not isolated, that this was a system, and that the only way to prove it was to drag that system into court and make it answer. What he could not have fully reckoned with in 2019 is what the courtroom would demand in return, because a British court does not simply receive a victim's testimony and ratify it. It tests it. It applies disclosure to both sides. It allows cross-examination. It permits the defense to introduce evidence that complicates, contradicts, and in some cases directly challenges the account that the claimant has spent years constructing in public. Harry built an identity around what was done to him. The British legal system, by design, interrogates identities. That is the mechanism now delivering the verdict back to him. Not hostile tabloids, not palace briefings, not the anonymous sources and unnamed enemies he has catalogued in memoirs and interviews and Netflix documentaries. The mechanism is the legal process he chose. The arena is the one he entered. The judge examining whether his account holds up is doing so because Harry stood in a British court and said, "Examine it." There is a particular kind of exposure that comes only from being taken at your word and then checked. And the check is now almost complete, which means the people watching most closely are not journalists or lawyers or royal correspondents. They are the ones whose future is structurally tied to what this verdict says about Harry, about the story, and about whether the foundation they built together on British soil still holds. That question, about Harry, about the story, about whether the foundation holds, gets its answer in the moment the verdict lands. Not in California. Not at a safer move across the Atlantic where a press statement can be drafted, refined, and released through a trusted intermediary on a controlled timeline. Here, in the UK, on British soil where the press he sued is headquartered, where the photographers waiting outside the courthouse know every angle, where every expression leaving a building becomes a front page by morning. The ruling comes down while Harry is physically present in the country he has spent years describing as the place that broke him. There is no managing that geography. And the ruling goes against him. Not partially, not in ways that allow for ambiguous framing. The judge finds that the Mirror Group's unlawful activity, while real in part, does not match the scale Harry described. His account, the very account that anchored his public identity, that powered the memoirs and the television hours and the carefully orchestrated interviews, is found to have been overstated. In some particulars, materially so. The legal word for what has happened is that his evidence did not hold. The cultural word is considerably more damaging. Because what Harry built after leaving the institution was not simply a life. It was an argument. The argument ran as follows. The press was predatory, the palace was complicit, the abuse was systemic and severe and deliberately ignored, and he and Meghan were its most exposed victims. Every deal, every interview, every public appearance was downstream of that argument. The Spotify contract, the Netflix series, the memoir, the Oprah interview, the UN speech. Strip away the victimhood and you are not left with a simpler story. You are left with a structural vacancy where the story used to be. That vacancy is what the verdict creates. And the timing ensures that the wreckage is immediate. There is no breathing room, no buffer zone, no week in Montecito to regroup before the narrative calcifies. He is here. Journalists are here. Cameras are here. The courtroom that delivered the ruling is 3 miles from the palace he walked out of and has not stopped discussing since. Every statement issued from his team lands inside the British news cycle on British terms, filtered through British editors who have been defendants in this very case. The idea that any response he gives in this moment will be received charitably is not naivety. It is the absence of any remaining goodwill to draw on. And then there is the Invictus visit, the one public role that has remained throughout everything genuinely unimpeachable. Veterans, injury, recovery, service. It occupied a separate moral register from the memoir grievances and the streaming deals. It was the thing even his harshest critics acknowledged with something approaching respect. He had kept it clean. He had kept it apart. Now it shares a news cycle with a legal defeat built on the claim of press abuse. Now every Invictus camera angle sits alongside courtroom coverage questioning his credibility. Now the veterans he is visiting are background texture in a story about whether his central account of victimhood was true. He did not choose that proximity, but he chose to come, knowing the trial was running, knowing the verdict was imminent, and the choice cannot be separated from its consequences. What it does to the Invictus brand, the one asset that was never supposed to be collateral, is perhaps the most quietly devastating part of all this. Meghan is not in the courtroom. She is not named in the verdict, but she is not separated from it either. Because the argument that the verdict has now partially dismantled was their shared argument. They gave it together. They built on it together. And if the press abuse narrative loses structural credibility, it does not lose it for one of them. The foundation does not crack on one side. When it goes beneath both of them. What this verdict ultimately delivers is not just a legal outcome, but a test of something Harry may not have fully anticipated when he filed. That courts do not trade in narrative. They do not weigh suffering against suffering or calculate moral score. They examine evidence. They apply standards. And when the evidence does not meet the standard, the court says so, regardless of what the evidence was meant to prove, regardless of how much it cost the claimant to bring it there, regardless of who is watching. Harry asked British justice to examine his story. British justice did. The verdict is the story now. If this is the kind of analysis that makes you look twice at what the headlines are actually saying, it is worth subscribing. There is a great deal more of this to come.